Good afternoon, everyone, and thank you for joining this webinar today about UK sanctions against Russia. My name is Claire Harrison. I head up the Business Awareness team in the Export Control Joint Unit, and we have coordinated the webinar today. My team is responsible for raising awareness and delivering training in person and webinar to industry on the requirements for export controls and specific process topics. I will introduce the speakers in a minute, but before I do, a bit of housekeeping. The webinar will be for 90 minutes. We have a lot of delegates today. We're expecting up to 2,050. We welcome your questions, and we will have a question and answer session at the end. If you wish to ask a question, please click on the speech bubble marked Q&A at the top of your screen and add your questions into the panel on the right-hand side. As a bit of context to today's webinar, the UK government has introduced and continues to put in place the strictest of sanctions against the Russia regime in response to their actions against Ukraine. The sanctions are wide-ranging, and a number of government departments are leading on them. Looking at the list of delegates we've got joining us today, many of you will have also joined the webinar last week with speakers from the Foreign Commonwealth and Development Department, HM Treasury, Department for International Trade, Department for Transport, Department for Business, Energy and Industrial Strategy. That webinar included energy and transport sanctions, which won't be covered in any detail today. The sanctions you will hear about today include prohibitions. This means no trade with Russia, either directly or through third parties. The information we are going to provide is advisory only, and it's not legal. We will signpost to where the legislation can be found, and it is your responsibility as exporters to read the legislation and work out for yourselves what actions you will need to take. You're advised to examine your own trading activities with Russia, taking legal advice as necessary, and take appropriate action. Next slide, please. I've just put up here the agenda for today that we had in the invitation, and some of the speakers also spoke at the webinar organised by Foreign Commonwealth and Development Office last week. That webinar recording is available. The webinar is also being recorded, and we'll start the recording now. So our first speaker today is Jeremy from the Foreign Commonwealth and Development Office in the Sanctions Task Force. And Jeremy will be talking about the scope of the sanctions. Over to you, Jeremy.
Great. Thank you very much, Claire. As Claire said, my name is Jeremy Lum. I work in the Sanctions Task Force in the FCDO, and I'm going to talk a bit about the Russia regulations and the Sanctions Act. So if we want to go to the next slide, please. So as you can see here, the Russian sanctions EU exit regulations came into force on the 31st of December 2020. They were brought over from the EU to continue the policy effect that we were having post Russia's incursion in Crimea. The sanctions regime merged 3 EU-Russia related sanctions into one bit of legislation in the UK. So this is something to bear in mind if you're ever trying to map UK and EU legislation against each other, that it's 3 in the EU and just 1 here. The regime contains measures and designations, and the difference between that is measures are prohibitions in legislation which can be applied in different ways. Some will be applied automatically and some apply to designated persons. So we'll be going into that in a bit in a second, but the one that would apply to a designated person are ones that I'm sure you've all heard of, which include asset freezes, travel bans and so on. You can see persons who are designated under the regime on the UK sanctions list. I'd recommend clicking in on that after this and familiarising yourself with it. Each time we designate someone new, they'll be added to that list, and it brings it all in one place and tells you exactly what the sanction against them is. So it would normally be for a person an asset freeze, a travel ban, And then if we think they potentially have a plane or a boat or so on, they might have the new travel sanctions against them. There's plenty of further guidance on the UK sanctions regime relating to Russia on gov.uk, and we've included the link there. Next slide, please. So the 2019 regulations, this slide sets out where we were before the crisis. So from the 2019 regulations, we had brought in the following list: the asset freeze, dealing with transferable securities and money market instruments, loan and credit arrangements, investments in relation to Crimea, travel ban, trade in military and dual use items, trade in energy related goods and related services, imports of any items originating in Crimea, trade in infrastructure related goods with Crimea, infrastructure and tourism services to Crimea, and movement of cruise ships to Crimea. And then that stayed the same for quite a while. So if we move to the next slide, you can see that we've amended it 8 times. 6 of those have been since February this year. So the first 2 were technical ones that happened at the same time as the legislation first coming into place. But then these ones from the 10th of February down are the more recent ones. So on the 10th of February, and that's Regulation 1, Amendment 1, we changed the designation criteria, and I'll talk about that a bit in a second. Amendment number 2, that brought in financial measures. Amendment 3 brought in trade measures. Amendment 4 brought in transport, specifically shipping sanctions. Amendment 5 was financial again, but related specifically to the central bank. And number 6 was transport again, with focus on aircraft, and it did a bit around aviation and space insurance and reinsurance. And that's where we are currently. Next slide, please. I would recommend you have a read through of the legislation yourselves when you get the chance. And the best way to do that, and this slide may seem a bit unnecessary apart from this, to go to legislation online and type in Russia sanctions EU exit, and it will come up with 2019, and then click into it. And then as that helpful arrow points out, if you click on the latest available revised, that will bring up the regulations, and it will bring up all those amendments on the last slide compiled into a single document. So if you click on original as made, it will be the outdated legislation. So make sure you've got the latest available. Normally it takes the legislation.gov.uk website a little bit of time to update these to make sure they're consolidated, apart from they've been doing it really fast recently, which is very helpful and makes it a lot easier to read and understand this legislation. Next slide, please. So I'm going to talk a bit about designations. So what we did on 10th of February was to change the designation criteria. We did this prior to the invasion of Ukraine, and it was to prepare the ground in case of invasion. The Foreign Secretary must have a reasonable ground to suspect an involved person, and that's a person who'll be for a person to be designated. The definition of this was initially fairly tight and was to do specifically with destabilizing Ukraine, and it's been like that since 2014. So we added in the below. So added in obtaining a benefit from or supporting the government of Russia to the definition of an involved person. And then we set out that this meant carrying on business as a government of Russia affiliated entity, carrying on business of economic significance to the government of Russia, carrying on business in a sector of strategic significance to the government of Russia, and owning or controlling, directly or indirectly, or working as a director, trustee, or equivalent of one of the above. So next slide, please. It also did the below, so that is, it defined the government of Russia affiliated entity as a person other than an individual, which is A, B, C, or D on your screen. I'll give you just a second to read that rather than reading out. And then on the next slide, this amendment also defines sector strategic significance to government as the following ones on your screen. So it meant that entities operating in these sectors can be designated. And as you can see there, chemicals, construction, defence, electronics, energy, extractives, financial services, information, communication and digital tech, and transport sector. So quite a variety there. Next slide, please. In addition to these to this amendment of the Russia regulations, we've also made changes to our primary legislation. So I'm sure many of you will have seen this in the past couple of weeks. The Economic Crime Act received royal assent last week, and it grants a plethora of new powers to respond to the ongoing crisis. But the ones that specifically us in the Sanctions Task Force are most interested in, we've listed out here. So it enables the UK to align more rapidly with designations imposed by our allies. So I'm sure you've seen some discussion in the press comparing us frequently to the EU or the US in terms of how we designate people and how quickly we can do that. Up until very recently, we had a bit more of an onerous process, but now we've changed the legislation, so an urgent designation procedure can be done to mirror our allies such as the EU, the US, Canada and Australia, and it also gives us the power to add other countries to that in the future if we wanted to do that. It streamlines and speeds up our decisions on UK sanctions by simplifying the statutory tests. So before we had to set out how something was appropriate, and we've now taken away that appropriate test. And it's stripped back on some unnecessary requirements to enable us to go faster. And we have definitely sped up in the past couple of weeks. And then finally, it ensures the government can designate groups or individuals more quickly by removing some of the constraints around designation by description. So again, you'll have seen how we have designated the entirety of the Duma, which is the Russian lower house, last week, which I think is around 380 people. Previously, we've had to do that individually and built up a case for each individual member, whereas now we can do it as a collective, which gives us a certain level of flexibility and allows us to move much faster when we need to. Next slide, please. So 2022, we have designated over 800 individuals and entities. And if you bring into that entities that are owned and controlled by these entities, it takes it to over 1,000. We've designated 26 businesses and over 69 oligarchs and elites and family members. And I'm sure you have all seen we did a few more today, so I'm not exactly sure what the exact number is right now. When we did these slides, this was accurate, but we continue to move very fast. And we've designated 10 key banks and their subsidiaries and the Russian Sovereign Wealth Fund. I think that's the end of my slides. Just to add on, in addition to the trade measures, there's also the other measures that I mentioned earlier, which goes quite far and wide across the Russian economy. I'm going to hand back now to Claire, I think.
Lovely. Thank you very much for that, Jeremy. Very clear, and I can see there's quite a few questions coming in the chat bar already, which we'll be asking at the end of the session, as I said. Our second speaker that I'd like to introduce is Chris Chu. Chris is head of the policy unit in the Export Control Joint Unit, and he's going to be talking about the scope and application of trade sanctions. Over to you, Chris.
Thank you, Claire. Good afternoon, everyone. Yeah, as Claire said, my name is Chris Chu. I had the policy team in ECJU. We're not responsible for the overall sanctions policy, but we are partly responsible for implementation of trade sanctions as they relate to UK exports and overseas trade. We're not responsible for imports, but we do work closely with the import policy team, and I've seen a few questions in the chat about the import measures, so I will just touch on those briefly. Next slide, please, Adrian. So just as an overview, what the trade sanctions apply to, what items. So in the legislation, they're referred to, well, there's a category which is referred to generically as restricted goods and restricted technology. and those restricted goods and technology include military items, and that's defined by reference to the UK military list in the export control order. And there's been an arms embargo against Russia since 2014. So if you're only just finding out about that now, then you're a bit behind the curve. They also apply to dual-use items, which are items listed in Annex 1 of the retained dual-use regulation. Now, up until March of this year, there were restrictions on supplying dual-use items to Russia that were for military end use or were going to a military end user. That's now been extended to a ban on export of all listed dual-use items to or for use in Russia. So that's an expansion of the previous sanctions that were in place. We've also introduced new prohibitions on what have been termed critical industry goods and technology, and these are listed in Schedule 2A of the Russia regulation. This list was, well, it derives from a US list. We worked very closely with the EU and the US in developing additional lists of items that would be subject to control, and it broadly follows the format of the dual use list, but it's goods and technology of a lower threshold or a lower technical specification than the items you find on the dual use list. So there's a range of items across materials, manufacturing, marine, electronics, and so on and so forth. There's also a separate category for aviation and space related goods and technology, and again that's listed in Schedule 2C, but effectively it's everything that's in Chapter 88 of the tariff, plus the related technology for development, production, and use of those items. So they're the kind of relatively new or changed things that have happened in terms of the sanctions recently. There's also the long-standing restrictions related to energy-related and infrastructure-related goods and services. They've not so far been amended or adapted, and also the specific measures that apply to imports, exports, and provision of certain services to Crimea. And I'll say something a bit more about that in a little bit. Next slide, please, Adrian. So where something is defined as one of these restricted goods and technology, then there's a wide range of prohibitions on things you can do with those goods and technologies in relation to Russia. So export, and that's export to or for use in Russia. So it doesn't have to be going directly to Russia, provided it is ultimately for use in Russia, then that would be caught by the prohibition. Supply and delivery from third countries to Russia. So you can't get around these sanctions by arranging for someone else in a third country to deliver the goods to Russia for you. That would also be caught. Making goods and technology available to a person in Russia, transferring technology, and then the provision of related technical assistance, financial services, funds, and brokering services that are related to those goods and technologies to Russia for use in Russia, and in the case of the technical and financial assistance and so on, it includes provision to a person connected with Russia. There are some additional prohibitions relating to insurance and reinsurance for aviation and space items, and that's the specific reason why we've carved out aviation and space into its own separate category, so that we can apply specific provisions to insurance for those items. And there's just a footnote at the bottom there that for the military items there are also prohibitions on imports and the acquisition and supply from Russia, as well as supply to Russia. Next slide, please. Now, if something is restricted, as I say, it's it's prohibited to do any of those activities that I mentioned earlier, but there are some exceptions and there are some grounds for licensing some of these items. So there are some limited exceptions that are set out in the regulations. And there are also set out in guidance on gov.uk the grounds on which we can license particular exports or transfers. And typically there are licensing grounds for prior contracts or a so-called grandfathering clause. So for example, for critical industry goods, we can license exports that are that form part of an obligation under a contract that was signed before the 1st of March, but we can only grant licenses until I think the end of May. So there is a cut-off date for that grandfathering clause. So if that applies to you, you need to check the cut-off date for the grandfathering clause, because after that date we won't be able to authorise the export, even if it is subject to a prior contract. And typically also there are exports for humanitarian purposes, for maritime and aviation safety, for medical and pharmaceutical use and so on and so forth. You know, the purpose of the sanctions is to target the Russian regime, put pressure on Russia by impacting its economy and its ability to acquire goods and technology that it uses for its undesirable activities. These are not targeted at ordinary Russian citizens, so some of these exceptions and licensing grounds do allow supplies in circumstances where it would be counterproductive to be prohibiting them. Now, for each of these categories of goods, the particular licensing grounds can vary, and the cut-off dates for any grandfathering clauses can vary. So you do need to check carefully. So look through the guidance and check whether any of them are relevant to your purposes. Where you think one of these licensing grounds does apply and you want to apply for a license, then you do so by applying through Spire in the usual way, and we'll consider that license application against the specific provisions of the sanctions, but we also assess it against the strategic export licensing criteria. So we do a kind of, it's one license application, but we do a check against all the relevant licensing criteria, sanctions related or sanctions specific or not. There are a couple of general licenses that we've introduced to meet specific needs. One is a time-limited license for aviation insurance, and that was just to match something that the EU had done and to prevent particular issues that were going to arise in relation to aviation insurance for that specific time period. And then we've also introduced a general license relating to certain maritime vessels that are undertaking journeys either to or from the UK to Russia or from Russia to third countries, but where the vessels themselves aren't being delivered or supplied to Russia. But other than those general licenses, if you do need a license and one is available, then it will be an individual license that, as I say, you apply for through our licensing database, Spire. Next slide, please. So quite a lot has happened in respect of sanctions, and we've been piling them on quite rapidly, but there's been quite a few things that have been announced but not yet implemented. So this is a non-exhaustive list of some of the things that are in train. So we've already announced that export of oil refining equipment is going to be prohibited. The EU has already done that, and I think the US may have done as well. So again, we'll be aligning closely with both of those. We're also working on the ban on export of luxury goods. We're still finessing what that list of luxury goods will look like. Again, the EU has published its list. What we do won't be a million miles away from what the EU has done, but I can't guarantee it will be completely the same. There are some nuances in there that don't make sense in a UK context, and some of what the way the EU has set it out doesn't quite make sense for us to do it the same way, but we're still working through those issues. But for an idea of what that will cover, look at the EU regulation that imposes that ban. It's also been announced that we'll be extending the current measures that apply to Crimea, so both on imports and exports, to the breakaway regions of Donetsk and Luhansk, and that's the non-government controlled regions of Donetsk and Luhansk. It's not all the kind of Russian occupied areas of Ukraine. The difficulty there, of course, is defining what those areas are, because the non-government controlled areas probably changes on a daily basis. So, there are some definitional issues there that we're still working through. And then again, I've seen some questions about the tariffs. So tariffs on imports, I think it's a 35% uplift on most tariff lines of imports from Russia and Belarus, and my understanding is that that's going to come into force tomorrow, and it will be the UK global tariff will be updated to reflect that fact, and I think there's a list on gov.uk of all the tariff lines that will apply to. So look out for that tomorrow. As I say, it's not my team's responsibility, but I'm aware of that happening. There are, of course, a range of other measures that might be imposed if certain things happen, or if Russia doesn't change its behaviour, but I don't want to speculate on what those things might be. The PM announced today that as part of I think it's a NATO or G7 meeting today, that gold was going to be the next thing to be targeted. So, undoubtedly there will be additional items that come under the purview of sanctions in future. So you do need to keep an eye on all this stuff because it will change. I think that's my last slide. If you move on one, just to check, Adrian. Yep, that was all I had to say on the trade sanctions. I'll be happy to answer any questions at the end, so I'll stop there. Thank you.
Thanks, Chris. I think I can see from the questions bar that as you've been speaking and as Jeremy had finished speaking, there's quite a lot of questions coming in about everything you've been talking about. So obviously we'll try and get those questions answered at the end of the event, but we'll go through those as we move on. Thanks very much for that. Now we're going to hear from Courtney. Courtney's from HM Treasury, Office of Financial Sanctions, and Courtney's going to be talking about financial sanctions, restrictions and general licenses. Over to you, Courtney.
Thanks, Claire. So yeah, as Claire said, I'm from OFSI at the Treasury, and as we heard earlier on, and as I'm sure you're aware, we've had an unprecedented pace over the last month or so, sanctioning over 1,000 individuals, entities, subsidiaries ever since Putin's invasion of Ukraine. This includes asset freezes on major banks, on oligarchs and on Putin himself. Adrian, can I have the next slide? Thanks. So I'd like to start by just looking a bit more at what is covered by an asset freeze. So an asset freeze is the most common form of financial sanction. When a person or entity's assets are frozen, you mustn't deal with funds or economic resources that belong to or are owned or controlled by that person, who we call a designated person, or DP, you might hear people referring it to it as well. So you also mustn't make funds or economic resources available to or for the benefit of a designated person. And in this sense, when we talk about dealing with, we mean moving, transferring, altering funds in any way. So it also covers receiving funds as well as sending funds. If you know or have reasonable cause to suspect that you're in possession or control of or any other way dealing with the funds or economic resources of a designated person, you have to freeze the funds and not deal with them. And we'd also like you to report to OFSI. You can report via our inbox, or there's also a reporting form on our website. So as well as asset freezes, the Russia sanctions regime has different financial restrictions in place. So there are restrictions on dealing with securities and money market instruments. There are restrictions on loans and credits, and there are restrictions on clearing and processing sterling payments for Sberbank, which is Russia's largest bank. So I'm not going to go into too much detail on those here, but you can find them listed in the Russian regulations, and also more about them in guidance that both OFSI and FCDO have published on gov.uk. And can I have the next slide, please? So just a bit more on definitions, because these are it's quite important to know exactly what is captured by these sanctions. The funds have a really wide definition, and it generally means financial assets of every kind. So it includes cheques, cash, securities, debt instruments, including stocks and shares, letters of credit, interest and dividends. Economic resources also basically covers assets of every kind which aren't funds but could be used to obtain funds. So that could be property, cars, yachts, jewellery, art, any of those kind of things would be covered by economic resources. And it's also worth noting that crypto assets are also caught within these definitions. So they're also covered by the funds and economic resources definition. And can I have the next slide, please? I'm just going to say a little bit about ownership and control. So some of the people designated have stakes in different companies. So it's just worth kind of looking at the OFSI position on ownership and control. So it's very important that individuals and companies that are subject to financial sanctions aren't able to circumvent the sanctions by setting up other companies, which they in reality own or control, or directing the actions of other individuals or entities which are under their control. So therefore, for the purposes of financial sanctions enforcement in the UK, we consider an individual or entity to be subject to the same financial sanctions if it is majority owned, which is more than 50% by a designated entity, or where it is controlled, either because of voting rights or share ownership or other rights. So this is always assessed on a case-by-case basis, but it means it's really important for companies to carefully consider not only the ownership of another company they're dealing with, but also look at its governance and its structure. So just a little bit, I know that aggregate ownership is something that we've been getting quite a lot of questions about. In case of ownership, so for example, if two designated persons each hold 30% of the shares of a company, OFSI would not aggregate ownership, so that wouldn't come under the ownership umbrella unless the shares or voting rights are subject to a joint arrangement between the designated persons, or one party controls the rights of another party. And can I have the next slide, please? Thanks. So you may need to apply for a license from OFSI under certain circumstances. So, for example, if a company becomes sanctioned that you're invested in, you might need a license to try and exit that position. OFSI licenses differ from trade licenses as they apply to the person or the company that is sanctioned, rather than sort of the object or the thing that you're trading. Licenses allow certain activity that would otherwise be prohibited under the regulations, such as payments. So we have two different types of licenses, specific licenses and general licenses. Specific licenses have to be applied for. They can't be issued retrospectively. So you need to apply for them well in advance and before the transaction takes place. You need to apply for a license under a specific licensing grounds. So I've listed the ones that apply to Russia here. There's quite a few different grounds that apply, but probably the most relevant ones are prior obligations. So this is for when a contract started before an individual was designated, and that would allow the payment to continue. But again, just need to state that you need the license before that payment can continue. Other common ones are ones for legal fees, the routine maintenance of funds and assets or holdings. So those are some of the more common ones. Can I have the next slide, please? We also have general licenses. These allow multiple parties to undertake specified activities without the need for a specific license. So we've issued quite a lot of these recently, and most of them are to do with sort of helping people wind down their positions with various banks. There are a couple of other ones. There's one for Chelsea Football Club to allow it to keep operating until the end of the season. So nearly all of these licenses that we've issued recently are for a limited time, and they just allow you to get out of your position for this limited time. If there are any issues with using any of these licenses that people are coming across, please do let us know. Next slide, please, Adrian. So on the final slide, we've just got a few links which should be useful for finding out a bit more about financial sanctions and OFSI. So there's a link to the OFSI website that's got loads of information on it. The OFSI blog, where we've published a blog with useful links to Russia. And there's a link to our guidance, which is also, we've updated our Russian guidance. So there's lots of things that I think you'd find useful on there. So thanks, Adrian. Sorry, back to Claire.
Courtney, thank you so much for that. You've got this slide up here, and just to say to everybody that's on the line, because you've been getting a few questions about will the slides be available as well. The answer is yes, they will be, and I think this slide is a really good example of why we need to make them available to everybody. So you will get the slides as well. Quite a few questions still coming in. Just keep them coming, please. For now, what I'd like to do is welcome Ross from the Department for International Trade, and Ross is going to outline the government's business advice service for Ukraine and Russia. Over to you, Ross.
Thank you, Claire, and hi to everybody on the call. I won't take up too much time, but just wanted to highlight, obviously, a lot of information that is being covered and a lot of aspects that the sanctions regime touches upon across multiple different departments and guidance in multiple different places. DIT has its export support service, which has previously been focused on trade with Europe. As a result of the invasion, we have and the sanctions, we've expanded the remit of the export support service to be the single point or the first point of contact across government for any questions that you might have related to trading with Ukraine, Russia or Belarus. The service is available via either a helpline, the numbers on the slide, or at the or through a digital form available again at the website that's listed on this slide. The helpline is currently available Monday through Sunday, 8 o'clock in the morning until 10 o'clock in the evening. And this service is there for you to ask all of your questions, and that can either provide them instantly if we have the answer to hand, or can work and coordinate with policy leads across government to be able to get the answer back to you as quickly as possible, where that question may be complex or have sort of specific sensitivities. I don't really want to add too much more than that, but just, you know, the export support service is there to help you with any question regarding this. Likewise, we've also, whilst it's obviously called the export support service, we have also obviously any question regarding trade or humanitarian aid. This service is also able to answer those questions. So I won't add anything more other than, you know, please do make it the first port of call if you have questions related to your business and trading with Russia, Ukraine or Belarus. Thank you.
Thanks, Ross. That's really helpful to know. I'm sure the delegates will find that really useful as a starting point into expanding into where they can find information, which government department is responsible for what. So please do take a note of that number, everyone. Well, thank you very much, Ross, for that. And finally, but not least, I should say, we've got Mark Scott. And Mark is joining us from the enforcement side of enforcement of strategic export controls in HM Revenue and Customs. He's the senior policy advisor in there, and he's going to talk about enforcement of trade and other sanctions. Thank you, Mark.
Yeah, good afternoon, everybody. As Claire said, I'm from the policy team within HMRC with policy oversight and all strategic export and sanction matters. So as you've heard from my colleagues today, this is very much led by the Department for International Trade and FCDO, who lay the statutory instruments, and they list the goods that are prohibited from export. So very much HMRC's position is the back end of stuff. So when goods get presented for export that are either sanctioned or going to a designated end user, that is when we come into play. And we do that in concert with our colleagues in Border Force, because they police the borders, as it were. And we also work closely with other parts of HMG when assessing the goods. So the question that everybody normally asks me when a sanction comes in is what will happen if goods get prevented and they get stopped at the borders and it's found to be in contravention. Well, what we do is we assess it on a case-by-case basis. There is no one answer that I can give you today that will fit all. If you do present goods for export that are in contravention of a sanction or a prohibition, then that creates its offence in itself. That's an offence contrary to the Customs and Excise Management Act. And that is something that we do for and on behalf of the Department for International Trade, because sanctions matters on export, and goods that are exported without the appropriate licence are an assigned matter proper to HM Revenue and Customs. So we do this. There are various outcomes available to us. As I said, it's a case-by-case basis, and it depends on what's the goods, where they're going, what steps you've possibly taken to try and prevent a breach of export controls. The list is quite voluminous. Can I have the next slide, please? Thank you. So presenting goods is a strict liability offence, so it's found committing. So there were goods, they were licensable and they were presented for export. So that's the offence there. And what we try and do is work with you to try and amend your export control regime to see if there's a knowledge gap, a loophole, and we'll try and work through it. What we're looking for really is people who are deliberately trying to circumvent export controls by going to neighbouring countries or disguising the load or putting the incorrect commodity code onto Chief or CDS. As you can see there, the penalties are I say penalties, but this is the actions that are open to us. So it can be anything from a warning letter all the way up to a referral to the Crown Prosecution Service for a charge to be laid. It is 10 years imprisonment, but that is a maximum prison, and anything in between. HMRC does a lot of post clearance audits. So whilst people may be exporting goods and getting goods through, we do have a lot of back end measures. So we do have quite a few teams within HMRC that will go around companies and audit your post clearance exports. So all I would say is if there's anybody there out there who has presented goods both now and in the future, and they think they may have breached export controls, the best measure is always to come forward and write to my team and tell us what you've done in the simplest terms, and we will treat every single infraction, as it were, on its merit and not as a sledge and hammer stuff. So I'm happy to field questions at the end of this, but I think that's all you need from now, I think, Claire.
Yeah, sorry about that, Mark. I was just, thank you. I was just trying to find my on mic button, and great that you've got all your contact points up there, and we'll be around to field any questions as they come in. I can see that you've already had some questions in while you've been talking, so that's good. Right, so thanks to everybody that's spoken. There's been some really excellent information, I'm sure you'll agree, that's been presented to you this afternoon. And as I keep going on about, there's been loads of questions as a result of all of that that have been piling in. I've got to say, I don't think we'll be in a position to actually answer all of these questions in the time that we've got allocated, but we're certainly going to give it a good go. So I'm going to move across to the speakers. I'm going to put some of your questions to the speakers and to the speakers that are going to be in a position to be able to ask what you've got down here. First question is related to EU sanctions. It's one for Jeremy, please. Jeremy, what restrictions apply if there's an EU sanction but no corresponding UK sanction? Will the UK be following the EU?
Thanks for that, Claire. So in general, we're well aligned with the EU, so prohibitions are likely to be the same, but if they're not aligned, EU sanctions don't actually apply in the UK. However, if you are registered in or operate in the EU, you will need to make sure that you're compliant with their sanctions.
Thank you very much, Jeremy. Chris, over to you. I've got quite a lot of questions here about the scope of the sanctions. And a common theme that's coming through is, where can I find a definitive list of sanctioned export goods, please?
So I'm afraid you have to look in two places for the list of sanctioned goods, or two places. So you need to look at the Russia regulation itself, and there you'll see the list of critical industry goods, the aviation and space goods and technology, the energy related goods and technologies, and also you'll see the list of items that are subject to specific measures for Crimea. So they're all set out in schedules to the regulations. For the military list items and the dual use list items, then you need to look at the consolidated strategic export control list that ECJU publishes on gov.uk, and I'm sure we can make the link to that available if it's not already available for people, but I'm afraid you do have to look in the two different places for those, for the complete list of items that are subject to restriction for Russia. Thanks.
Yeah, thanks for that, Chris. And it's a good point about where the different restrictions are and which different bits of legislation you actually have a look at. I wonder whether it's also worth saying that we've issued a couple of notices to exporters in the last few weeks, and in those notices to exporters, we've very clearly laid out where the actual pieces of legislation are and which pieces exporters actually have to look at. So I probably would encourage companies to go back through the notice to exporters and have a look at how to get through to all those links on the legislation. That's one thing I'd probably be encouraging companies to do. Courtney, yeah, I could see all these questions coming in as you were talking, I have to say. I've got a question here about entities. What happens if the parent entity is not Russian but has a subsidiary in Russia?
Thanks, Claire. So that's a really tricky one, actually. It kind of depends on the situation. So it's hard to know whether the subsidiary would be captured or not by the sanctions without knowing which specific one it is, because obviously sometimes subsidiaries are captured. And obviously there's quite a lot of the restrictions on securities and money market instruments and loans and credit arrangements have a wider range than just the designated persons and the asset freezers. So I'm afraid you just need to undertake your due diligence and sort of consider whether the company is designated or owned or controlled by a designated person, and whether any of those restrictions that I just mentioned apply to the company.
Lovely. Thank you very much for that, Courtney. Chris, I'm coming back to you now. Question here, will Russia be added as a licensable country to UK trade sanctions, dual use export classifications, for instance, the PL controls?
So in that specific case, no, because effectively the things caught by those controls, and for people that aren't aware, they're specific controls on marine and aviation that apply for exports to Iran, I think is the only destination, but they're effectively now caught by the critical industry list and the aviation and space related list. So there's no need to add Russia to that specific list in that case.
Okay, thanks very much. Jeremy, question here relating to sanctions in terms of risks of diversion, because obviously what we said at the beginning was that a lot of these prohibitions that are in these sanctions actually relate to direct export and also export through third parties. So I've got a question here. Where do UK exporters stand regarding diversion risk and indirect shipment for parts that can be normally exported to the EU and other countries, where there could have been end use in Russia, or for customers who we know have, our customers in the EU have traded with Russia? Where do companies stand on that, please?
Thanks, Claire. So to kind of start off similarly to my other question, so we're well aligned with the EU, so prohibitions are likely to be the same, but in instances where they're not, note that the UK prohibitions apply for use in Russia. So even if the good is exported to a third country, it's still important that you undertake your due diligence that you deem necessary to make sure that the use is not intended for in Russia.
Lovely, thank you very much for that answer. And while you're on, Jeremy, there was we did have you detailed out there, and I think Courtney did as well, about the medical and healthcare products. The question here is, are medical and healthcare products exempt from sanctions?
Thanks again, Claire. So most of our prohibitions include licensing grounds for, I think, humanitarian, medical and food. So it's worth checking back on the legislation and guidance. But specifically on medical licensing, I think there's or there is licensing for is it critical goods and for dual use goods.
Okay, so then this particular area goes on about if they're exempt for humanitarian reasons, which you've just stated, can we give advice about how you deliver the products to Russia if there's a freight embargo? I don't know whether that's in your area, but if there's a freight embargo, how do you then go on to deliver the products?
As far as I'm aware, there is no freight embargo. So this actually is a bit more in my area than usual, in that I've been looking at transport sanctions. So there's no prohibition on non-Russian ships in and out of the UK. So cargo from Russia can come on non-Russian ships as long as it's not cargo that's prohibited under the trade ban.
Thank you very much. Thank you very much for that. Courtney, I'm going to come to you. You mentioned about sanctions on particular banks, and there's a specific one here. How should we treat any relationship with Sberbank when it's not officially under sanctions?
Thanks, Claire. Yeah, Sberbank isn't subject to an asset freeze. There are some restrictions which do apply to it. For example, there's a restriction around processing a sterling payment, which includes clearing and settling a payment. So OFSI has issued 2 general licenses with regard to Sberbank. One of those allows for the wind down of various financial positions, and one of those allows for the clearing of energy payments. So you definitely want to consider using one of those general licenses depending on what trading you're wanting to do with Sberbank. Thanks.
There's another question on getting paid here as well, if you would.
Yeah.
How do we get paid how do we get paid now that the methodology of payment through SWIFT has been blocked if the goods were delivered prior to the conflict?
So yeah, I mean, SWIFT is a bit trickier. So SWIFT is actually a Belgian company. So I can't really comment on that because that would come under the EU umbrella. But I mean, you can certainly apply for a license from OFSI to get a payment, and if the goods have already been delivered, that could well be covered by a prior contract license. So do consider applying for a license from OFSI. When you apply for that license, if you put as much information as you can in the application about the transaction and about the payment method that you want to use, that would be the best chance of having a successful license application. Thanks.
Marvellous, thanks, Courtney. Ross, I've got a question here about the Export Support Service. Will the Export Support Service be able to answer questions on interpretation of specific prohibitions of UK-Russia sanctions regulations?
Thanks for that. So no, unfortunately. What we can do is we can provide you links with the guidance and provide essentially as much detailed information as we can. What we will not be able to do is essentially make legal or sort of business decisions, or I'll give legal advice or business advice in that space. That isn't something we are unfortunately able to do. What we are able to do is make sure that we can provide all the guidance we can, but ultimately it will be for the business or individual to make the decision. And we do recommend, if it is, potentially, a legal implication, that external legal advice or independent legal advice is sought in that space. So that's a longer answer for essentially saying no, we won't be able to, but we will try as much as possible to give as much information as we can.
Thank you. Mark, I've got one for you here, which talks about enforcement of the sanctions, and if somebody's been found to have breached the sanctions, will that information appear in the public domain anywhere about their breach? And how long will it appear in the public domain for?
Okay, thanks, Claire. No, we don't put them out in the public domain per se, because it depends on what enforcement action, if any, is taken against that company or that individual. So if it were to be a warning letter, for instance, then that's just kept on file for a period of 6 years, which is HMRC's retention period. If it was to be a fine in lieu of a file being prepared and sent to the Crown Prosecution Service for the consideration of a charge, then when you paid a fine, there is an agreement between the two parties that any fine will be published in notice to exporters, but it is anonymised. If there is sufficient evidence and it's in the public interest to do so, and the Crown Prosecution deem that somebody should be taken to court to answer for what they've done, then of course that would be public, because it's in the public domain, the evidence. Hope that assists.
Okay, thank you very much. So again, it's really important to keep an eye on things like notices to exporters, isn't it? And what's going out there. Courtney, question for you here. If a party is financing or ensuring a deal to which trade sanctions apply, does the license application, for example, in relation to winding down trade financing, go to OFSI or to the Export Control Joint Unit?
So again, I'm afraid it depends on the specific circumstances of the deal. So some trade sanction licensing also relates to the financial services that are associated with the trade of a prohibited good. But if a designated person or entity is involved, then you would need a license from OFSI. So sometimes you need to apply for a license from both ECJU and OFSI to cover the different aspects of a deal. Okay,
thanks very much. Jeremy, I've got one here about general licenses, because there were various, you mentioned about exports of basic needs. Will there be a general license issued for the provision of basic needs, utilities, civilian telecommunications to or in Russia and for sanctioned entities and individuals?
Thanks, Claire. So I'm not quite clear from the question what is meant by sanctioned entities or individuals. If referring to an asset freeze, licenses available from OFSI for basic needs. Licenses are available from OFSI for basic needs of the designated person. Where it relates to humanitarian needs, licenses can also be granted. For dual use prohibition, there's a licensing ground for civilian telecommunications networks as well. So hopefully that covers it.
Okay, thank you. Chris, I've got a couple of questions on dual use goods. What do sanctions mean for dual use items being sent to Russians in other parts of the world?
Well, it's not prohibited to send a dual use item to someone in a third country simply because they're a Russian national. Obviously, you need to think about whether the items are ultimately for use in Russia. But if it just happens to be a Russian passport holder in a third country, then that on its own is not subject to the sanctions. But obviously, as I say, you need to think about whether it's ultimately for use in Russia.
Right, and I've got a similar question related to dual use. So this is dual use goods which are controlled and which are restricted. If those dual use goods are being sent to another country for incorporation into non-controlled end product items and then being shipped to Russia, is there a stop on those types of dual use goods leaving the UK?
No, if the goods are effectively incorporated into another product, so they cease to be, the widget ceases to be the widget, then no, it wouldn't be caught. I mean, under the dual use regulation, there's a general principle called the principal element rule, where the controls do apply if the component is the principal element, i.e. it makes up a significant part of the thing being exported, then that is subject to the controls. But if it's, I don't know, something fairly small that's then being manufactured into something else in a third country, so that it loses its identity in effect, then no, that's not caught by the sanctions.
Not caught by the sanctions. Okay, that's helpful, thank you. Courtney, there's a few questions here about payment. Can a money transfer continue to work with a Russian company that's non-sanctioned, which can pay out the transaction via a sanctioned bank in Russia or Belarus? can a money transfer continue to work with a Russian company that's non-sanctioned, which can pay out the transaction via a sanctioned bank in Russia or Belarus?
I mean, I would say that if the transaction is touching a sanctioned entity, then it wouldn't be able to proceed without, at least not without a license from OFSI.
So that would require a license?
I think that would require a license, if I'm understanding it correctly, that you want to pay it via a sanctioned bank. Yeah, you wouldn't want to transfer funds via a sanctioned bank.
Okay, so, and it would require, in any case, would require them coming to you for a license.
Yeah,
because it's still part of due diligence, isn't it?
Yeah, exactly. So that's why you have to consider sort of every part of the chain, and you have to kind of think about if anyone's sanctioned within the chain, you want to think very carefully about whether you can make that transaction or not.
Yeah. Okay, that's very, very useful advice. Thank you. Jeremy, I've got one here. This is concerning the employment of Russian nationals in the UK. Are there any rules regarding hiring Russian nationals or citizens into the UK?
Well, if they're designated, you won't be able to pay them, or they won't be able to travel to the UK because they'll have a travel ban. But I assume this is for non-designated persons, and I would just refer you to the usual immigration rules that the Home Office have, so on gov.uk. There's nothing specifically around sanctions on employing Russian nationals. Yeah.
Okay. Thank you. Chris, I've got a question here on technology know-how. Probably needs a little bit of an explanation about what we class as technology. Could you talk a little bit about the scope of sanctions relating to technology, and in particular open source software, mass market crypto?
Yeah, thanks.
Is this covered by the critical industry technology provision?
Yeah, okay, thanks. So I presume the questioner knows, but for those that don't know, in export control terms, we talk about technology as meaning information which is necessary for the development, production or use of goods or software, and where the goods and software are controlled, then generally speaking, the related technology for the development, production and use is also controlled. We also tend to class source code as being technology, in most cases anyway, and in export controls in general, there is an exemption for technology that is in the public domain, and that is generally understood to include open source software. So that's how export controls normally work. In the Russia sanctions, there is no exemption, basic exemption for information in the public domain. So open source software would potentially be caught, including for kind of consumer electronics and telecommunications devices that employ cryptography. However, there is an exception in Regulation 60B, which is for software updates for consumer devices, and there's also a licensing ground, or in fact two licensing grounds, which apply, I think, to dual use and critical industry, or at least the critical industry list. One is for cyber security, and that allows you to supply software and technology to persons and companies in Russia other than those that are owned or controlled by the government of Russia. So this is, normal kind of cyber security for firms, for example, or individuals who happen to be in Russia. And also, as I think was mentioned in respect of an earlier question, there's a licensing ground relating to the operation and maintenance of civil communications networks in Russia. So yes, it's caught, but yes, it's licensable, I think, is the short version of the long answer. Thanks.
Yeah, no, thank you. Thanks very much for that. I think I've got a question here for, I think it's either Jeremy or Courtney. So whichever one of you thinks that you're best placed to answer it. If a Russian company is building something in a country outside of Russia, for example, a nuclear power plant, can we supply if the goods never enter Russia? Is that a Courtney question?
I mean, from my perspective, so long as there's no one involved in the chain that's subject to an asset freeze, that sounds okay, but I can't say for certain. I'm not sure about the goods and things, but so long as there's no one, it sounds to me like as long as there's nobody who would be subject to any of the sanctions restrictions within the chain anywhere, it sounds okay. I don't know if Jeremy wants to come in.
I would have just echoed that, saying if it's, because I was talking earlier about stuff for use in Russia, if it's not being used in Russia and it's not linked with a designated person, then it sounds okay. It sounds okay, but yeah, I'd have to check.
Okay. I think we'll probably make this one the final question. It concerns dealing with Ukraine. Given Russia has invaded Ukraine territory, so there is a potential for payments, aid, technology that is sent to Ukraine and it could fall into Russian hands. Are there any bars to dealing with Ukraine, and how do they find out if they can do that?
Well, in terms of trade sanctions, there are no specific measures applying to Ukraine other than Crimea, and as I mentioned, to be introduced applying to the non-government controlled areas of Donetsk and Luhansk. But other than that, there are no measures that apply to Ukraine that don't apply ordinarily under the military or dual use controls. I think, yeah, people need to do their due diligence, and there is always a risk that things might fall into Russian hands if, for example, Russia occupies territory it didn't previously occupy, but where there's a humanitarian crisis and infrastructure needs to be repaired, or etc., then that risk exists. Obviously, if things are licensable anyway, military or dual use, then we will take those risks into account when we assess license applications for them. But as I say, other than the controls that exist for all destinations, there are no specific trade sanctions against Ukraine apart from Crimea and to be the Donetsk, Luhansk. Thanks.
No, thank you, Chris. On that final question. Well, thank you. We've heard an awful lot this afternoon, and I do have to say that's the end of the webinar for today. For delegates, just to let you know that a recording of this webinar will be sent to you as we've got your sign up details, so you get a copy of that and also a copy of the slides, because as we said, there was quite a lot of useful contacts in the slides. I'd like to thank Adrian Bond and Denise Carter in my team for giving this webinar its platform and enabling you all to participate. We couldn't have done it without them. And finally, a big thanks, of course, to all you speakers for your expert presentations and for answering all those myriad of questions. There are a lot of questions there. We hope we've answered the areas that we were choosing, the areas where it seemed that there was a lot of questions in those particular subject areas. We will go through the questions and provide answers that we haven't actually provided answers to. And just to say, we'll keep you informed of any further webinars, either on this subject or other strategic export control related events that we'll be doing. Before we close, I have been asked to remind you all that the Export Control Joint Unit has recently issued a customer service questionnaire to help inform our improvement programme for the Strategic Export Licensing Service. Please take time to complete it and submit it back to us, because your feedback is very important to us as we move forward. This last slide I'm going to leave as the main contact slide for you all, as it's the government's main contact point on Ukraine and Russia. And thank you very much for being with us.